As legal scholars Jeffrey Walker and Craig Hemmons contend, the first 10 amendments, also known as the Bill of Rights, were intended to apply only to the national government. However, beginning in the early 1960s, the Bill of Rights was also held to be binding on the states through the 14th Amendment, which guarantees due process. This essentially means that the U.S. Supreme Court established minimum standards to be applied by criminal justice employees at the state level. Let me provide an example of how the 14th Amendment works. Take, for example, the exclusionary rule, which was discussed last week. In 1914, the U.S. Supreme Court announced a strong version of the exclusionary rule in the case of Weeks versus United States. This decision, however, created the rule only on the federal level. It was not until almost 50 years later when the court in Mapp versus Ohio, 1961, ruled that the exclusionary rule was also held to be binding on the states. In this groundbreaking decision, the court held that the 14th Amendment, which guarantees due process, meant that all state and local law enforcement agencies were bound by the exclusionary rule. Up until Mapp, the exclusionary rule had been rejected by most states. Just as a reminder for those of you who may not remember, the exclusionary rule holds that evidence collected or analyzed in violation of the defendant's constitutional rights is sometimes inadmissible for a criminal prosecution in the court of law. There is something interesting that is definitely worth pointing out. The U.S. Supreme Court only establishes minimum standards of conduct, so states through legislation may actually require stricter standards of conduct. For example, New York state law, through its courts, has actually expanded constitutional protections for its residents. Given this, state officials must not only be familiar with federal law as well as federal court decisions, but also state statutes and court decisions. So, criminal justice employees as well must be familiar with all of these laws. Again, the states can give more rights to its citizens, but they can never give citizens less rights than what they are guaranteed under federal law or the Constitution. Let's now turn to legal scholar Darrell Ross's discussion of civil liability under state and federal tort law. As we mentioned last week, negligence and intentional torts form the basis of civil liability. Negligence occurs when a person fails to exercise due care. He or she may not intend to harm another person, however, an injury nevertheless ensues. According to Ross, for a plaintiff to prove a state tort negligence claim, 4 elements must be established. First, the defendant must have a legal duty to act. Where no legal duty exists, there is no liability. Remember that a legal duty is not to be confused with a moral duty. Typically, legislatures or criminal justice agencies pass laws or implement policies which specify the duties of law enforcement personnel, creating a legal duty to act. Next, in order for a plaintiff to prove a state tort negligence claim, he or she must show that the law enforcement employee failed to perform or breached a legal duty. If the plaintiff is successful in establishing that there was a legal duty and that the employee breached this duty, then he or she must show that this failure to act was, in fact, the proximate cause of the injury. In other words, a close causal link between the employee's negligent conduct and the harm must be demonstrated. Finally, if a state tort negligence claim is to succeed, the plaintiff needs to demonstrate that an injury did in fact occur. In other words, the plaintiff must show that actual damage occurred as a result of the criminal justice employee's negligent behavior. As we discussed last week, one common area of negligent state tort law involves the operation of motor vehicles. Many states require a rather high standard, which is commonly referred to as gross negligence. Other states have lower standards, such as reckless disregard. It is important to remember that when a judge or jury will determine the verdict, they are nevertheless human beings who are subject to error, and they may not always get it right. Hypothetically, one case could be decided differently depending upon who exactly is in that jury box. So remember, while policymakers and judges try very hard to craft precise legal definitions, it is fair to say that the interpretation may vary from juror to juror or from judge to judge. Other examples of negligent state tort laws include wrongful death suits as well as failure to protect suits. When discussing failure to protect suits, it is important to remember that the U.S. Supreme Court established the public duty doctrine, which essentially means that law enforcement personnel are not liable for failing to protect a particular victim of a crime. There are, however, exceptions to the public duty doctrine. For example, there may be what is referred to as a special relationship. If, for instance, a pretrial detainee is placed in a jail, the county jail employee may very well have a responsibility to protect this individual who's under custody. This will be especially true if the jail employee should have been able to foresee a possible injury. It is important to note that plaintiffs file negligent torts under state law. So, what would happen if a federal agent engaged in an act of negligence? The answer is interesting. If a plaintiff wanted to sue a federal agent, he or she would actually have to sue this individual in a federal court under the Federal Tort Claims Act. This suit must be based upon tort claims, not a constitutional violation. Alleged constitutional violations involving federal employees would be handled in other ways. Let's talk for a minute about Section 1983 lawsuits now. In Chapter 4 of his book, Civil Liability and Criminal Justice, Darrell Ross reminds us once again that if a plaintiff sues under Section 1983, he or she must show that the defendant acted under color of law. Courts have held that a criminal justice employee acts under color of law whenever they wear official uniforms, draw their agency-issued firearms, identify themselves as law enforcement officials or correctional officers, or hold themselves out as an official personnel member for a governmental agency. So, an off-duty police officer who assaults an unsuspecting citizen typically will not have acted under color of law. The only exception might be if the officer was to have used official equipment or in some way used his or her authority as an official employee. Remember that pretrial detainees, probationers, convicted prisoners, and parolees may file Section 1983 lawsuits. Some courts even allow illegal aliens to file Section 1983 lawsuits. Also, if you remember from last week, individuals like to file Section 1983 lawsuits because the discovery procedure tends to be more liberal and more in their favor. Also, as Ross argues, these plaintiffs might be reimbursed for attorney fees. In Section 1983 suits, the damages awarded are similar to the damages in state court claims in that they might be nominal, compensatory, or punitive. Nominal awards may consist of only $1 or $2, whereas punitive damages are likely to be substantial. Usually, if a criminal justice employee is sued under Section 1983, an attorney will be provided to represent this employee so long as the employee acted within the scope of his or her authority. Generally speaking, employees are provided quite a bit of leeway in this respect, and as long as the employee did not commit an egregious offense, more than likely representation will be provided. And if the employee loses the civil suit, the agency usually pays the damage, which is referred to as indemnification. Of course, most agencies will not indemnify blatant or outrageous actions outside of the employee's authority. And very, very seldom will agencies pay for punitive damages. There's one final bit of information which is important in understanding Section 1983 lawsuits. Typically, plaintiffs will sue not only the individual employee who was involved in the incident, but also those in the chain of command. This is where you, as a future or current manager of criminal justice personnel, might become involved. Yes, if you are a supervisor, you can be named in a Section 1983 lawsuit if one of your subordinates engages in a questionable act. Also, governmental entities are often named in Section 1983 lawsuits. The reason for this is due to what is known among legal scholars as the deep pockets theory. Presumably, rank-and-file criminal justice employees have only limited resources, so it is much more advantageous for a plaintiff to identify supervisors, administrators, as well as the governmental entity such as the City of Killeen. Also bear in mind that Section 1983 lawsuits may be filed both simultaneously in state and federal courts, but remember, the mere fact that a Section 1983 lawsuit has been filed does not necessarily mean that a criminal justice employee's conduct was improper. This will ultimately be up for the court to decide.